Hello everyone, thank you for joining this Your Overseas Home webinar. My name's Rosie, I'm a senior copywriter at Your Overseas Home. It's great to have so many of you with us today, whether you're watching live or on demand. Today we'll be chatting with Leah Maynard, a senior French executive at Buckles Solicitors, about your legal considerations that you should think about when moving to France. So before we get started, Leah, please can you introduce yourself with our viewers and tell us a little bit about what Buckles does?
Hi everyone and good afternoon. My name is Leah. I am one of the lawyers with the French team at Buckles, and as you will get from my accent, I am French. I work at Buckles, which is a full-service law firm, and in our French law team, we advise our British clients on French property and inheritance laws.
Lovely, thank you. So to all of our viewers, we do invite you to ask questions. Any questions you have for Leah throughout the presentation, we've got a questions tab on the right-hand side of your screen. And we have got a little presentation for you today, and we'll be answering questions afterwards. We do hope to answer as many queries as we can today, but if we don't get round to them all, don't worry. Any unanswered questions will be forwarded to Leah and the team at Buckles. So over to you, Leah.
So today I really wanted to focus on the preliminary contract, which is the most important step in your property purchase journey, because it will set up all of the terms and conditions that have to be met for your purchase to go ahead. The first point I wanted to touch on is on the differences between the types of preliminary contract. The two standard ones are what is called the compromis de vente, or reciprocal promise to sell and purchase, that's the legal way of saying it, or what is colloquially called a promesse de vente, which is a promise from the seller to sell a specific property to a buyer. The difference between compromis and promesse de vente is quite important, because in a compromis, both the buyer and the seller are legally committed, whereas with a promesse de vente, the seller is the one who is legally contractually committed, and then the buyer has an option to purchase a property. It doesn't mean that the buyer can just walk away from the purchase at any time. What it does mean is that if you don't want to go ahead and are happy to forfeit your deposit, your seller cannot force you to complete on the purchase, whereas with a compromis, they potentially could, and they could claim additional damages. So generally, if you're a buyer, a promesse de vente is a little bit more protective of you than a compromis de vente. However, if your estate agency is the one drafting the contract, usually they will have a preference for the compromis de vente because it does not need to be signed in front of a notaire. So both types of contract present, pros and cons that needs to be considered carefully before deciding which one is right for you. The second very important element in your preliminary contract is your conditions precedent. A condition precedent is a condition that if it is not met, then the purchase and sale will not go ahead. It will completely fail altogether. Under French law, we have what are called general condition precedents, which apply to all types of sale and purchases. The first one, obviously, is that there is good title to the property. You don't want to buy a property that your seller doesn't actually own. That would be very bad. So what will happen is that your contract will be subject to the seller being able to prove good title to the property. The notaire would check that, and the title has to go back 30 years. So it is quite a thorough check. Second condition is that there is obviously no charge registered against the property, because you want to buy your property free of charge, and you want to make sure that no lender can come and bother you to pay somebody else's mortgage off. So likewise, that's something that the notaire will check for you between signature of the preliminary contract and completion. And if there are charges that the seller is not able to pay off, then you will not have to proceed with the purchase. Another general condition is in terms of the public easements. What I mean by public easements are easements that are for the benefit of the local authority, and they are quite an important consideration, because for the condition precedent not to be met, the public easement would have to significantly impact the enjoyment of your French property. So what will happen is that the notary will get what is called a town planning certificate, and then you will be provided with this between signature of your preliminary contract and completion. Very often there is a poor understanding of what public easements would allow you to withdraw from the purchase. It needs to be significant. For example, the house has to be destroyed for a road to go through it. So something like finding out between signature of the contract and completion that there is going to be a wind farm built next to the property would not necessarily constitute a public easement major enough for you to be able to withdraw from the purchase. And that's important because it means that those inquiries have to be made before you sign your preliminary contract, because this condition precedent will not protect you otherwise. Another one that is quite specific to France is your preemption rights. Preemption rights is when the local authority has what is called a right of first refusal over the purchase. So what will happen is that once you sign your contract, the local authority will be notified of the sale, and they will be asked whether they would like to purchase the property instead of you. If they say yes, unfortunately, there is nothing you can do, and your seller will have to sell to them. But obviously, it's a very important condition to be met, because if the notary does not serve the appropriate notice, then the local authority has 5 years to get the property to them and basically evict you out of it. So obviously, it's very important to make sure that this condition is met. Otherwise, the specific conditions precedent that are even more important are mainly the condition of financing and the condition of planning permission. Financing at the moment is extremely key because it is extremely difficult to get a mortgage in France at the moment. So you need to make sure that your mortgage condition precedent of financing is properly drafted, that it meets what you have agreed, for example, with your mortgage broker, and that you understand what you have to comply with to make sure that this condition is met. For example, you need to check how many refusal letters would allow you to withdraw from your purchase. Very often there is a misunderstanding that if you make a mortgage application and you get rejected, well, then that's it, you can't purchase the property and you can just walk away. That's actually not always the case, and sometimes you can have a condition that plans for 3 refusal letters to be provided before you can walk away from your purchase. So obviously you need to be ready to have your mortgage application submitted to different various lenders to meet this requirement. The risk obviously is that if the condition fails due to your fault because you did not understand what you were supposed to do about it, then you could potentially risk losing your deposit, also damages claims from the seller. So this condition precedent is really the one to look out for. Otherwise, another important condition precedent is planning permission. A lot of people buy properties in France, and obviously they've got brilliant plans with their property. They want to extend it to be able to host family. They would like a swimming pool, etc. And sometimes it is just so important that you would not want this property if you could not go ahead with your plans. And what is important to understand is that there are different types of planning permission condition you can put in a contract. The first one is called planning permission in principle. So that would be a certificate that says, yeah, in principle, you could build a pool. This one does not give you any kind of protection. You could have it and then make your actual planning permission and be rejected. The only way to be 100% sure that you will be able to carry out your planning plans is to have full planning and what is called purge of objections. So it's a planning permission that has been displayed on the property for a certain amount of time, and then everybody's right to object has passed. Only then can you be 100% sure that you will be able to carry your plans. Obviously, this does add a very long time. It can put a purchase up to a year between contract and completion. But if your swimming pool is important to you, then it should take a year to make sure that you get the property the way you would like it. So again, very important to understand it, understand exactly how it protects you and whether you can withdraw or not if you can't get your planning permission. Other conditions you can find in a contract are often more minor, which is why they are called special conditions rather than condition precedent. It means that you would very much like them to be fulfilled, but if they are not fulfilled, you won't be able to withdraw. However, you can claim damages from your seller. Very often is something is broken and you would like your seller to fix it, or there is a lot of rubbish in the barn that you would like the seller to come and pick up, etc. So you always have to ask yourself whether a condition of your purchase is important enough that you would not want to proceed if the condition was not met, or whether it would be nice to have it and you would like to get some contractual options to enforce it, but you would still want the property at the end of the day.
Okay, so that's more for like something that would cause you an inconvenience, but you would still go ahead with the contract if that wasn't met. Yeah.
Yes, exactly.
Cool.
Another provision that will 100% catch your eye in your preliminary contract is the one that gives you the overall purchase fees and also the conditions surrounding your deposit payment. In France, the buyer pays all the conveyancing fees. Those are called the notaire's fees, which is not very fair to notaire because they actually don't get that much out of them, but usually they cover the French equivalent to stamp duty, the registration taxes. So basically, they're all like taxes that you pay to the French state. And in France, they are quite high. They're around 8% of the sale price. So you need to be sure that you have budgeted for those in addition to the purchase price that you're paying for the property. The deposit, in France, you should expect to pay a deposit of either 5 or 10% of the purchase price. And this specific provision of the contract is important because it will tell you when exactly your deposit is due. It changes every time. Nobody does it the same in France. Usually it's either 10 days after signature of the contract, 15 days after signature of the contract. Obviously, don't pay a deposit before you have signed your contract. That's bad. But usually you've got those very tight timescales. That means you have to make sure that you've got your currency sorted out, etc. So do take careful attention to this provision. Another one that gets quite technical is that the contract will inform you of any building work your seller has carried out on the property, whether they did obtain planning permission, and you will be surprised as to how many people actually never bother to get planning permission, and whether they obtain the relevant building insurance. Building work is very important, especially if you have your own plans for the property, because if planning permission was not obtained when it should have been, then the local authority can refuse any further planning permission on the property until this is regularized, and they don't have an obligation to regularize it. So let's say you buy a very nice property, you're very happy, the seller converted the garage into an extra bedroom. It means you can have your family over, but you would like a swimming pool. Turns out the seller didn't get planning permission to convert his garage into an additional bedroom. And even though the house and the pool can seem in your mind completely separate from each other, the local authority could say, no, you have an illegal bedroom, you can't get a swimming pool either. And obviously, if you have to then turn your bedroom back into a garage, that's going to be a massive inconvenience and be very, very expensive. So you really have to pay close attention to this. The French do very often shrug off any building work issue. You will probably be met by everybody does it that way in France. But no, that's not the case. And if you get a local authority that decides to be difficult, and sometimes they are, then there is no remedy that you have. So you can buy the property without planning permission. You just have to have a good understanding of the risks and what it means for you. Another condition that is quite technical is your provision about easements. Easements is something, as simple as a right of way. So Mr. Farmer in the field nearby is allowed to go through your garden to reach the road. Or otherwise, you've got pipe work easements. So somebody has their drainage pipes going under your property. Obviously, this is something that you need to have a good understanding of when you purchase a property, because it will affect your ownership. If there is a right of way, you should understand who uses it, What for? Does it cause damage to the property? Does it cause inconvenience? Obviously, if you've got tractors going through your garden at 6 o'clock in the morning, that's not something that is going to make you very happy when your family get to take some holiday in your house, etc. Easements are difficult to understand because they're drafted in a very legalese language, and the best way to understand them is to just take your plan, take your easement, and go and actually look at the property itself and see how it works in practice. Another important point, to be fair, they're all important, so I will keep saying another important point. Your cooling off period and completion deadline will be indicated in the contract. In France, every buyer of residential property gets what is called a cooling off period. The cooling off period starts the day after you are notified of the signed contract and the annexes. So there is no concern that you should have that by receiving the contract, your cooling off period has started running. It will only start running after you have signed it and all the mandatory documents are annexed to the contract. And you have 10 calendar days during which you can change your mind for any reason and nobody can say anything about it. If you have paid any deposit, it has to be returned to you within 21 days if you decide to exercise your right of withdrawal under your cooling off period. The completion deadline is one that is very confusing for us in England. It's because in England, when you put a completion date in a contract, it is a firm completion date. That's the date on which completion will happen. In France, the deadline is a little bit more relaxed in that it is a deadline, not a firm date. So it is the latest date at which completion can happen before parties can start serving each other notices, getting angry that nothing has happened, etc. But it can also be extended, for example, if paperwork is missing. So that would be local authority hasn't replied to their preemption notice, you can extend your completion deadline. So there is always a fair amount of negotiations going on between buyer and seller to check when you will complete. So at the time of signing your contract, you will have an idea of what is expected, but it won't actually be your firm date, and you should not make any plans based on the date on the contract. Usually you will get a completion date around 2 weeks before the deadline is what we find happens as well. While the contract is obviously very important, the annexes to the contract also should not be ignored. And what we find sometimes is that people get a translation of the contract, but they don't get a translation or advice on the annex documents, which is a mistake because they will provide you with a lot of very, very important information on your purchase. If you're purchasing an apartment, for example, you have to be provided with a set of what is called loi allure documents, and those would be information on your co-ownership charges that you will have to pay every quarter. It will be information on the past 3 Assembly General meetings, information on the budget, etc. So all of this will give you financial information as to how much this apartment is going to cost you every year in copropriété charges. And even the minutes of the Assembly General meetings are quite interesting to read because then you can notice if everybody in the apartment building is extremely difficult to deal with. You can notice if people just aren't paying towards building work, etc. And obviously, if you've got 3 years of meetings where everybody is arguing and nothing is happening, is this really an apartment building where you want to have to deal with those people? Obviously, in France, you will be provided as well with a set of survey reports. They're very different from what we would have in the UK. Those are paid for by the seller, and they cover topics such as, is there asbestos at the property? Is there presence of lead? Is the gas system secure, etc.? So do go through those carefully, because while the seller does not have to make good on any of the issues, obviously for you, they are important to budget how much any repairs would cost. If you see the electrics are completely outdated, then obviously you would have to budget to get that fixed. Something that has become very relevant today in France is your energy performance certificate. So the EPC used to be just a document that people would kind of ignore because it was just for information purposes. France has introduced new laws to battle energy wastage in properties in France. And basically what happens now is that if you've got a property with a poor energy performance rating, such as F or G, you will have an obligation as buyer to carry out building work to make your property energy efficient. And that means that the seller also has to now provide you with an energy audit. The energy audit will give you costings as to the building works that will be required to bring your property up to the expected energy standard. And where it is very important is that if your property's energy standard is too low, you cannot rent it out. And there is actually expectations that at some point the French government might say, actually, you cannot sell your property until you fix the energy, because France just wants to get rid of all energy inefficient properties. So that is something that will give you an indication as to potential costly building works that you would be expected to carry out on your property. Another piece of potentially expensive building work is your drainage. In France, we still have a fair amount of properties that are not connected to main drainage, especially in beautiful rural France. You will have a septic tank, which is not very glamorous, but it is what it is. And in France, for every sale and purchase of a property with a septic tank, the local authority will come and check if the septic tank is compliant with current norms. Most of the time, it isn't. Very often, you will find the septic tank is either too small for the property, or it's not been set up properly, it's missing part of it. And likewise, this is something that you have to budget for, because if you have to bring your septic tank into compliance, making comply with those requirements, then you only have a year from the date of purchase to finish your building work under the supervision of the local authority. If you have to install a septic tank brand new, it will cost you around 10,000 to 15,000 euros. So obviously that's something that you need to take into account and potentially use as a negotiation point with your sellers. There are also things that we would expect to be covered under French law, but actually they're not. The French are not bothered at all about structural surveys. That's just not something that they do. I don't know why. I quite like the idea of a structural survey personally. What this means is that if you tell your seller, I want the purchase to be subject to a satisfactory structural survey, you will get told no. You will get told no because the seller will say it is too subjective. What I could be fine with in a structural survey, you could find is an issue, and then it basically gives you a get out of jail free card. So what usually happens is that if you do want a structural survey, there are actually British risk surveyors who now live and practice in France, so you can get a survey done, but you would need to get it done before you sign your contract or before your cooling off period expires, because otherwise you will, even if the survey reveals a massive issue, you will not be able to use it to withdraw from your purchase. And the last point is that something that I know British people very often argue about is boundaries. When you buy a property in France, you are not given any guarantees as to the boundaries of the property. You will be given a land registry plan. The boundaries on the land registry plan are not legal boundaries. They are not enforceable in the courts. They are not enforceable against your neighbors. They're just here for tax purposes. So obviously, if you feel that they could potentially be a bit of a question mark on the boundary, for example, there is a field, you are not sure where your property stops and where the field starts, the only way to have legally enforceable boundaries is to have a land surveyor come and put little marks along the boundary. Once this is done, a proper plan will be created, and that will be absolutely legally enforceable. However, your seller will not give you a guarantee, and if you want your boundaries marked, this is something that you have to do at your own cost. So potentially, you could pay for that to be done, and then something else happens, and you don't proceed with your purchase, and you will not be able to get your money back. The only time you get an actual guarantee in terms of surface area is if you purchase an apartment. If you purchase an apartment, part of the service will include a surface area guarantee. And then if you find out within a year of the sale that actually the property is much smaller than you were told in your survey, you can get refunded pro rata of your purchase price. So obviously, surveyors usually do a very good job, but if you feel that maybe this is not quite the 100 square meters that you thought you were purchasing, do get it resurveyed quite quickly after your purchase, because you do have this option under French law to get some of your money back. And that's it for all of those things to look out for in your preliminary contract. I will leave you on the slides of the timeline of a property purchase while we take some questions.
Yeah, of course. Sounds great. Thanks so much, Leah. My boyfriend sat next to me, and he's a surveyor here in London, and he's been nodding along the whole time.
Oh, well, I'm glad I've got his approval.
Okay, so we have time for some questions now. Susan's asking, she assumes all the documents are in French, like primarily, right?
Oh yeah, everything will be in French. Nothing will be in English.
Okay, so is it possible to get an English translation?
Yes, you can absolutely get an English translation. What I would say, and you will say expected answer from a lawyer, is that a translation is not giving you legal advice. And often what happens is that people get their contract translated, and actually it still doesn't make any sense, even in English. You will be told, for example, Article 1792 of the French Civil Code applies to this purchase. Well, total amount of goods that tells you to know that. What does this article mean? How does it apply to me? Is it actually something I should worry about, etc.? So that's where legal advice rather than translation does have, the added benefit that somebody will tell you, somebody that is in your corner only with no vested interest in the purchase completing will tell you, yes, that's a worry, or no, don't worry about that one. They have to put it in there, but actually it's not a problem for this property.
Mm-hmm. And is that a service that Buckles offers?
Yes, that is our main service when assisting on a purchase. So basically, we would get involved around the time that you sign your purchase offer, because we want to look at anything you are asked to sign. And then we would prepare for you a very detailed report on your contract, going through it provision by provision, just, saying, this looks worrying, but actually it's not, or this one is glossed over, but actually you need more information on that. And then we will liaise with whoever drafted the contract to get the paperwork you need, or to say, actually, this is very important. Can we make this a condition precedent? Here is what I want the condition to be worded, because I feel this is more protective of my buyer, etc. And then we just monitor the transaction until completion.
Lovely. So you're kind of there to add the much needed context about these laws.
Yes, exactly.
Fab. Okay, we have a question from Paul. He's asking about building work. Can we find absence of planning permission before signing the contract? And if not, can I withdraw from the contract if my building plans are likely to be rejected by local authorities?
So that is going to be the importance of your building planning permission. It is unlikely that you will be able to find out whether you can get your planning permission on the contract before you sign a contract. The reason for that is that the property is not yours, and technically you're not allowed to apply for planning permission on a property that does not belong to you. So if you want to apply for planning permission, you have to have your seller's consent, and that is recorded in the contract. So that's where the drafting of your planning permission condition is very important, because you have really to put dates, etc. For example, an architect will apply for planning permission by that date. The answer will be received by that date. And if any of the steps falls, then you have to have your right of withdrawal properly protected.
Okay, fab. Does the cooling off period apply to a compromis and a promesse?
Yes.
Yeah, both of them?
Yeah. Cooling off period is statutory in French law. You're not allowed to waive it. If you are buying in your personal name, you will benefit from it. You only don't benefit from it if you are purchasing through a company, but that's something that only happens in very rare cases. So if you're buying a property normally in your own name, you will get your 10 days cooling off period.
Okay. Kyle's asking, are there any plans to up the EPC? I'm guessing this is like the regulations from F to G or to something higher.
So France is planning to have all French properties within A to D ratings by 2035. So they have like a very step-by-step plan in that I can never remember the years, but basically in the next 3 years they don't want any F or G, then they will get rid of E, and then so on and so forth. And by 2035, there will be very, very harsh penalties for a property that is not up to standard in terms of energy performance. But you can get grants and things like that, and the energy audit report will give you all of the information that you need to make that decision.
Okay, cool. So would you recommend that people kind of try and get it as high as possible, or do you just kind of aim for F at the moment?
No, don't. F is literally like the worst. Don't aim for F. You should aim to go as high as possible, and the energy audit will give you building work to bring it to the current acceptable rating, and they will also give you an idea of building work and cost to bring it to the best rating the property can achieve. It's really a fantastic document. I've only seen two because the obligation only started from April, but they are incredibly useful for buyers, and it's a really good new piece of legislation.
Okay, cool. And how can you access that?
Your seller has to provide it to you before you sign your preliminary contract. It's part of the mandatory documents now.
Okay, fab. What else have we got? Richard asks, does being a cash buyer actually speed up the process at all?
I want to say not really. In theory, it does. In theory, a cash purchase would take 2 months from contract to completion, and then a mortgage takes 3 months for contract for completion. The truth is that notaries are so busy that I've never had a purchase complete in 2 months. It hasn't happened to us in years. So the usual timescale is 3 months, whether you are a cash buyer or have a mortgage.
Okay, fab. Zoe is asking, this is quite a long one, so bear with me. Her and her husband want to buy a property outright in Normandy as their full-time residence. They've got half the amount in cash, but the rest needs to come from the sale of their UK home. Is the time frame generally as long for cash buyers as mortgage buyers? In the slide, just want to know how long we have from paying deposit to paying the full amount.
You will have to pay the full amount by the completion deadline. The full amount needs to be in the notaire's account at least 3 days before your agreed completion date. Obviously, at the moment in France, because mortgages are so difficult to obtain, a lot of people are planning to finance their purchase by the sale of a property in the UK. What I can tell you from experience is that it does not work if you try to tie your UK sale to your French purchase. Notaires at the moment will simply not agree to put a condition precedent that you have to sell on your UK property before you can buy in France. That's because they think that, and they're not wrong, the UK selling process is completely capricious and random, and nobody actually knows when a property is sold or not, which is fair enough. So if you are hoping to sell your UK property, you need to sell it and you need to move into temporary accommodation while you go through with your French property purchase. Otherwise, it is just a logistical nightmare and very, very stressful, because you could absolutely lose your 10% deposit because you did not manage to sell your UK property in time.
Are there any cases, this is just a personal question, are there any cases where you could make a deal with the seller to kind of put half down and then pay the rest however long in advance later on, I mean?
Yeah, so that is allowed under French law. It's called a vente à terme, where you basically complete and then you pay your sale price at a later date. I think my manager has seen it once, and she's been doing French law for 30 years. So I think that tells you just how a notaire is unlikely to agree it, especially with a seller who doesn't live in France, with a buyer who doesn't live in France, because then it just becomes very difficult to enforce if you don't pay, the sale price when you were supposed to.
So it's quite rare.
Very rare, yeah.
Okay. I've got another question here. We're unsure how to structure our purchase. Is it something we need to decide before we sign the preliminary contract?
So no, not at all. What you can do is have what is called a substitution clause added to your preliminary contract. And the use of the substitution clause is that it allows you to substitute another buyer instead of yourself at the time of purchase. So you can use it to change. For example, you were buying it together, then you're only going to buy it in your sole name. You can do that. Or if you decide you want to buy through a company, then you can use your substitution clause to substitute the company instead of yourself. Or if you actually decide you want to buy with your children, then that's fine. You can use it to add your children. However, you need to take advice and make a decision before completion, because there are some ownership structure options, such as the tontine, which is very popular, that can only be added at the time of purchase.
Okay, fab. Susan's asking, I have answered this because I actually know this one, you'll be proud. She doesn't have French residency. Is it still advisable to purchase a property in France, or should we rent until we're certain you'll be given residency? So you don't need residency to buy in France, do you?
No, so you don't need residency to buy in France. Obviously, if you are planning to move to France permanently, and I can see why you would want your residency before you move. I have so far not heard of anybody in England who has moved to France and been denied residency. I have heard that it takes ages. I have heard that it's an absolute headache to deal with the French administration. But so far, I have not heard of anyone who's been told no and kicked out of France.
Mm-hmm. Yeah. So say you have bought your property, you moved to France. How long do you have before you need to apply for a long-term visa, that kind of thing?
I think it really depends on your plans. I don't practice immigration law, so you would have to speak to an immigration law specialist in terms of getting residencies, etc. So one point I would want to make is that if you are planning to apply a visa to be able to stay more than 6 months a year in France, even if it's not on a permanent basis, you will be considered tax resident in France, which means that you have to start paying income tax, capital gains tax in France on your worldwide assets and income. So obviously, that's something that you need to consider before you make your visa application.
Okay, fab. Rich is asking, why would a seller be willing to sign a promesse rather than a compromis de vente, as a compromis seems to bind both parties, whereas the promesse only binds the seller? Is that right?
Yes, that's correct. It's a promesse de vente does also have some benefit from the seller because there isn't a reciprocal undertaking from the buyer. If the seller puts the buyer on notice to complete and the buyer doesn't comply, the seller immediately gets to put the property back on the market. Whereas with a compromis de vente, both parties are basically stuck with each other. The seller could force the buyer to complete. The buyer could force the seller to wait until they're ready 6 months, a year, to sell the property to them. Whereas with the promesse de vente, it is a lot easier for each party to take back their freedom, unless you have paid the sale proceeds already as a buyer, in which case your seller will have to complete.
Okay, fabulous. Ian's asking, I'm not sure if you'll be able to answer this, but let me know if you don't.
Yeah, give it to me.
Ian's asking, his wife and him intend to retire to France with their personal pension. What's the minimum amount we need to prove to earn as a couple to be able to live there?
I don't know that.
Yeah, I thought so. Don't worry.
Sorry, Ian. I don't know.
I will send you a link, Ian, and it will help. Don't worry. Okay, so let me just have a look what other questions I have. Okay, what are the do you know what the main tax considerations are when one moves to France?
So many of them. Yes, so when you move to France and you become French tax resident, you will have to consider income tax because France will get to tax your worldwide income. You will also have to consider capital gains tax because if you sell a property in another country while you are resident in France, you become liable for French capital gains tax. And obviously, the big one for me, because I advise on will and inheritance tax, is that you have to realize that France will levy French inheritance tax on your worldwide estate. And the French inheritance tax rules are quite strict and the rates are very high. I had a couple that I advised a couple of months ago who were living in France, and one of them had stepchildren, and they wanted to leave their assets to their stepchildren. And I had to tell them, you can do that, but they will have to pay 60% of French inheritance tax. And believe it or not, they're now moving back to the UK because they just can't stomach that this is a thing that actually happens in France. So obviously, moving to another country, while it is a beautiful dream, it is also a massive change in your life, and you should really take full legal advice, because you don't want to be happy and settled in a country and then find out suddenly that there is this horrible tax that will be levied against you.
Okay, we have time for a couple more. So have there been any recent changes in policy that could affect property buyers?
That is a wide question. I think the main one really is the one on energy performance. Like France is really, really cracking down on it. Another one is that France is slowly phasing out one of its property taxes, the taxe d'habitation. And now you have to report how your property is used. If you own it as a holiday home, you will have to keep paying the taxe d'habitation. But if you actually live in the property, you will now be exempted from that. So that's a little bit of a saving. Yay, less taxes. We don't get to say that very often.
Great news. Okay, we've got another question come in. Can you change your mind after signing the offer on your house, or is it too late?
You can absolutely change your mind after signing an offer. Basically, what the offer does is that it will set out the main terms and conditions, the ones that you really can't do without, and it will usually give a sort of timeline to sign the preliminary contract. However, you still get your 10 days cooling off period after you sign your preliminary contract. So the offer cannot bind you as a buyer because you are protected by your 10 days cooling off period. However, for the seller, it's quite different because they can be considered to be legally committed from the signing of the offer. And certainly, if you really, really love that property and the seller decided to mess you around after signing the offer, you could potentially go as far as forcing them to sell the property to you.
Oh, okay, cool. Okay. And what happens? So one of the first steps is obviously the preliminary contract. So what immediately happens once that's been signed?
So once you've signed your preliminary contract, your 10 days cooling off period will be triggered. And then usually after the 10 days has passed, you will have to pay your deposit, either within the 10 days or quite quickly afterwards. And then basically, as buyer, you will feel that nothing happens for a couple of months. Actually, there is a lot going on behind the scene because the notaire will start doing the searches. They will start to look at whether there are any public easements. They will check the title. They will check that there are no charges, etc. If you've got a planning permission condition, then you are very busy with your architect trying to get that planning permission through within the timescales. If you've got a mortgage, you are also very busy stressing out about your mortgage application. But otherwise, it can be a quiet time. And then in France, usually everything starts kicking off again 2 weeks before the planned completion date.
Okay, fab. Let me just click onto the next slide, which has your contact details.
Yes.
Adrian, great timing. You're reminding me to tell you all that this webinar will be available on demand tomorrow. We'll send you all an email with the link to rewatch. So you'll have access to these slides and be able to rewatch mine and Leah's enlightening conversation. So yeah, that's about all we've got time for today. Thank you, Leah, for all your tips and advice. It's been super helpful. We strongly recommend for everyone who's watching and everyone watching on demand that you do get in touch with Leah and Buckles directly to discuss your requirements in detail, as they'll be able to give you much better advice depending on your situation. So thank you so much, Leah. It's been great to see you again. Thank you to all our listeners for viewing. And before we finish, I'd look to invite you to leave us a review on Trustpilot if you found this remotely helpful. Thanks again, and happy property hunting in France.
Thanks, Rosie, and bye, everyone.
Thanks, Leah. Bye.
Bye-bye.